We will continue argument this morning in Case 11-398, the Department of Health and Human Services versus Florida. General Riley.
Mr. Chief Justice, and may it please the Court, the Affordable Care Act addresses a fundamental and enduring problem in our health care system and our economy. Insurance has become the predominant means of paying for health care in this country. Insurance has become the predominant means of paying for health care in this country. For most Americans, for more than 80% of Americans, the insurance system does provide effective access. But for more than 40 million Americans who do not have access to health insurance, either through their employer or through government programs such as Medicare or Medicaid, the system does not work. Those individuals must resort to the individual market, and that market does not provide affordable health insurance. It does not do so because the multi-billion-dollar subsidies that are available for the employer market are not available in the individual market. It does not do so because ERISA and HIPAA regulations that preclude discrimination against people based on their medical history do not apply in the individual market. That is an economic problem, and it begets another.
Why aren't those problems that the federal government can address directly?
They can address it directly, Justice Scalia, and they are addressing it directly through this act by regulating the means by which health care is purchased. That is the way this act works. Under the Commerce Clause, what Congress has done is to enact reforms of the insurance market directed at the individual insurance market that preclude discrimination based on pre-existing conditions, that require guaranteed issue community rating. And it uses and the minimum coverage provision is necessary to carry into execution those insurance reforms.
Can you create commerce in order to regulate it?
That's not what's going on here, Justice Kennedy, and we're not seeking to defend the law on that basis. In this case, what is being regulated is the method of financing the purchase of health care. That itself is economic activity with substantial effects on interstate commerce. And
so any self-purchasing, anything if I'm in any market at all, my failure to purchase something in that market subjects me to regulation.
No, that's not our position at all, Justice Scalia. In the healthcare market, the healthcare market is characterized by the fact that, aside from the few groups that Congress chose to exempt from the minimum coverage requirement, those who for religious reasons don't participate, those who are incarcerated, Indian tribes, virtually everybody else is either in that market or will be in that market. And the distinguishing feature of that is that people cannot generally control when they enter that market or what they need when they enter that market.
The same, it seems to me, would be true, say, for the market in emergency services. Police, fire, ambulance, roadside assistance, whatever. You don't know when you're going to need it. You're not sure that you will. But the same is true for health care. You don't know if you're going to need a heart transplant or if you ever will. So there's a market there. In some extent, we all participate in it. So can the government require you to buy a cell phone because that would facilitate responding when you need emergency services? You can just dial 911 no matter where you are?
No, Mr. Chief Justice, I think that's different. I don't think we think of that as a market. This is a market. This is market regulation. And in addition, you have a situation in this market not only where people enter involuntarily as to when they enter and won't be able to control what they need, what they enter, but
it seems to me that's the same as in my hypothetical. You don't know when you're going to need police assistance. You can't predict the extent to emergency response that you'll need. But when you do, and the government provides it, I thought that was an important part of your argument, that when you need health care, the government will make sure you get it. Well, when you need police assistance or fire assistance or ambulance assistance, the government is going to make sure, to the best extent it can, that you get it.
I think the fundamental difference, Mr. Chief Justice, is that that's not an issue of market regulation. This is an issue of market regulation, and that's how Congress looked at this problem. There is a market. Insurance is provided through a market system.
Do you think there is a market for burial services?
For burial services?
Yes.
Yes, Justice Alito, I think there is.
All right, suppose that you and I walked around downtown Washington at lunch hour and we found a couple of healthy young people and we stopped them and we said, you know what you're doing? You are financing your burial services right now because eventually you're going to die and somebody's going to have to pay for it. And if you don't have burial insurance or you haven't saved money for it, you're going to shift the cost to somebody else. Isn't that a very artificial way of talking about what somebody is doing? And if that's true, why isn't it equally artificial to say that somebody who's doing absolutely nothing about health care is financing health care services?
I think it's completely different. And the reason is that the burial example is not — the difference is here you are regulating the method by which you are paying for something else, health care. And the insurance requirement, I think the key thing here is my friends on the other side acknowledge that it is within the authority of Congress under Article I, under the Commerce Power, to impose guaranteed issue and community rating forms, to impose a minimum coverage provision. Their argument is just that it has to occur at the point of sale.
I don't see the difference. You can get burial insurance, you can get health insurance. Most people are going to need health care, almost everybody. Everybody is going to be buried or cremated at some point.
Well, one big difference, Justice Alito, is you don't have the cost shifting to other market participants.
Sure you do, because if you don't have money, then the state is going to pay for it. Or a family member is going to pay for it.
That's a difference, and it's a significant difference. That in this situation, one of the economic effects Congress is addressing is that the many billions of dollars of uncompensated costs are transferred directly to other market participants. It's transferred directly to other market participants because health care providers charge higher rates in order to cover the cost of uncompensated care, and insurance companies reflect those higher rates in higher premiums, which Congress found translates to $1,000 per family.
But isn't that really a small part of what the mandate is doing? You can correct me if these figures are wrong, but it appears to me that the CBO has estimated that the average premium for a single insurance policy in the non-group market will be roughly $5,800 in 2016. Respondents, the economists who supported the respondents, estimate that a young, healthy individual targeted by the mandate on average consumes about $854 in health services each year. So the mandate is forcing these people to provide a huge subsidy to the insurance companies for other purposes that the Act wishes to serve. But if those figures are right, isn't it the case that what this mandate is really doing is not requiring the people who are subject to it to pay for the services that they are going to consume? It is requiring them to subsidize services that will be received by somebody else.
No, I do think that's what the respondents argue. It's just not right. I think it really gets to a fundamental problem with
if
their
you're going to have insurance, that's how insurance works.
A, it is how insurance works, but B, the problem that they're identifying is not that problem. The guaranteed issue and community rating reforms do not have the effect of forcing insurance companies to take on lots of additional people who they then can't afford to cover because they tend to be the sick. And that is, in fact, the exact opposite is what happens here. When you enact guaranteed issue and community rating reforms and you do so in the absence of a minimum coverage provision, it's not that insurance companies take on more and more people and then need a subsidy to cover it. It's that fewer and fewer people end up with insurance because the rates are not regulated. Insurance companies, when they have to offer guaranteed issue and community rating, they're entitled to make a profit. They charge rates sufficient to cover only the sick population because health.
Could you help me with this? Assume for the moment, you may disagree. Assume for the moment that this is unprecedented. This is a step beyond what our cases have allowed, the affirmative duty to act to go into commerce. if that is so, do you not have a heavy burden of justification? I understand that we must presume laws are constitutional. But even so, when you are changing the relation of the individual to the government in this, what we can stipulate is, I think, a unique way, do you not have a heavy burden of justification to show authorization under the Constitution?
So, two things about that, Justice Kennedy. First, we think this is regulation of people's participation in the health care market. And all this minimum coverage provision does is say that instead of requiring insurance at the point of sale, that Congress has the authority under the commerce power and the necessary proper power to ensure that people have insurance in advance of the point of sale because of the unique nature of this market, because this is a market in which although most of the population is in the market most of the time, 83% visit a physician every year, 96% over a 5-year period. So virtually everybody in society is in this market, and you've got to pay for the health care you get. The predominant way in which it's paid for is insurance, and the respondents agree that Congress could require that you have insurance in order to get health care or forbid health care from being provided.
Why do you define the market that broadly? Health care. It may well be that everybody needs health care sooner or later, but not everybody needs a heart transplant. Not everybody needs a liver transplant.
That's correct, Scalia, but you never know whether you're going to
Could
be
you
that
define
person.
the market? Everybody has to buy food sooner or later, so you define the market as food. Therefore, everybody's in the market. Therefore, you can make people buy broccoli.
No, it's quite different. It's quite different. The food market, while it shares that trait that everybody's in it, it is not a market in which your participation is often unpredictable and often involuntary. It is not a market in which you often don't know before you go in what you need, and it is not a market in which if you go in and seek to obtain a product or service, you will get it even if you —
Is that a principled basis for distinguishing this from other situations? I mean, you could also say, well, the person subject to this has blue eyes. That would indeed distinguish it from other situations. Is it a principled basis? I mean, it's a basis that explains why the government is doing this, but is it a basis which shows that this is not going beyond what the system of enumerated powers allows the government to do?
Yes, for two reasons. First, this is the test, as this Court has articulated it, is Congress regulating economic activity with a substantial effect on interstate commerce. The way in which this statute satisfies the test is on the basis of the factors that I have identified.
Mr. Verrilli, I thought that your main point is that unlike food or any other market, when you make a choice not to buy insurance, even though you have every intent in the world to self-insure, to save for it, when disaster strikes, you may not have the money. And the tangible result of it is, we were told, there was one brief that Maryland hospital care bills 7% more because of these uncompensated costs. The families pay $1,000 more than they would if there were no uncompensated costs. I thought what was unique about this is it's not my choice whether I want to buy a product to keep me healthy, but the cost that I'm foisting on other people if I don't buy the product sooner rather than later.
That is, and that is definitely a difference that distinguishes this market and justifies this as a regulation.
All right, so if that is your
activity.
difference, I'm somewhat uncertain about your answers to, for example, Justice Kennedy asked, can you, under the Commerce Clause, Congress create commerce where previously none existed? Well, yeah, I thought the answer to that was, since McCulloch versus Maryland, when the court said Congress could create the Bank of the United States, which did not previously exist, which job was to create commerce that did not previously exist, Since that time, the answer's been yes. I would have thought that your answer can the government, in fact, require you to buy cell phones or buy burials, that if we propose comparable situations, if we have, for example, a uniform United States system of paying for every burial, such as Medicare burial, Medicaid burial, CHIP burial, ERISA burial, and emergency burial beside the side of the road, and Congress wanted to rationalize that system, wouldn't the answer be yes? Of course they could. And the same with the computers, or the same with the cell phones if you're driving by the side of the highway and there is a federal emergency service, just as you say you have to buy certain mufflers for your car that don't hurt the environment. You could — I mean, you see, doesn't it depend on the situation?
It does, Justice Breyer, and if Congress were to enact laws like that, we
would be up here
my responsibility.
All right, so then
defend them, and I would defend them on a rationale like that. But I do think that we are advancing a narrower rationale.
But then the question is whether or not there are any limits on the Commerce Clause. Can you identify for us some limits on the Commerce Clause?
Yes. The rationale purely under the Commerce Clause that we're advocating here would not justify forced purchases of commodities for the purpose of stimulating demand. It would not justify purchases of insurance for the purposes in situations in which insurance doesn't serve as the method of payment.
But why not? If Congress says that interstate commerce is affected, isn't, according to your view, that the end of the analysis?
No. We think that the difference between those situations and this situation is that in those situations, Your Honor, Congress would be moving to create commerce. Here, Congress is regulating existing commerce, economic activity that is already going on, people's participation in the healthcare market, and is regulating to deal with existing effects of existing commerce.
That, it seems to me, and it's a passage in your reply brief that I didn't quite grasp. It's the same point. You say health insurance is not purchased for its own sake, like a car or broccoli. It is a means of financing health care consumption and covering universal risks. Well, a car or broccoli aren't purchased for their own sake either. They're purchased for the sake of transportation or, in broccoli, covering the need for food. I don't understand that distinction.
The difference, Mr. Chief Justice, is that health insurance is the means of payment for health care.
Well, now that's a significant — I'm sorry.
And broccoli is not the means of payment for anything else. And
it's the means of satisfying a basic human need, just as your insurance is the means of satisfying.
But I do think that's the difference between existing commerce, activity in the market already occurring, the people in the healthcare market purchasing, obtaining healthcare services, and the creation of commerce. And the principle that we're advocating here under the Commerce Clause does not take the step of justifying the creation of commerce. This is a regulation.
Can we go back to — and Justice Breyer asked a question and it kind of interrupted your answer to my question, and tell me if I'm wrong about this, but I thought a major point of your argument was that the people who don't participate in this market are making it much more expensive for the people who do. That is, they will get — a goodly number of them will get services that they can't afford at the point when they need them, and the result is that everybody else's premiums get raised. So it's not your free choice just to do something for yourself. What you do is going to affect others, affect them in a major way.
That absolutely is a justification for Congress's action here. That is existing economic activity that Congress is regulating by means of this rule.
You could say that about buying a car. If people don't buy cars, the price that those who do buy cars pay will have to be higher. So you can say, in order to bring the price down, You're hurting these other people by not buying a car.
That is not what we're saying, Justice Scalia.
That's not what you're saying. I thought it was. I thought you're saying other people are going to have to pay more for insurance because you're not buying it.
No, it's because you're going in the healthcare market, you're going into the market without the ability to pay for what you getting the healthcare service anyway as a result of the social norms that allow that to which we've obligated ourselves. So people
don't obligate yourself to that. Why?
I can't imagine that the Commerce Clause would forbid Congress from taking into account this deeply embedded social norm.
You can do it, but does that expand your ability to issue mandates to the people?
This is not a purchase mandate. This is a law that regulates the method of paying for a service that the class of people to whom it applies are consuming or inevitably will consume.
General, I see or have seen 3 strands of arguments in your briefs, and one of them is echoed today. The first strand that I've seen is that Congress can pass any necessary laws to affect those powers within its rights, i.e., because it made a decision that to affect mandatory issuance of insurance, that it could also obligate the mandatory purchase of it. The second strand I see is self-insurance affects the market, and so the government can regulate those who self-insure. And the third argument, and I see all of them as different, is that what the government is doing, and I think it's the argument you're making today, that what the government is saying is if you pay for if you use health services, you have to pay with insurance, because only insurance will guarantee that whatever need for health care that you have will be covered, because virtually no one, perhaps with the exception of 1% of the population, can afford the massive cost if the unexpected happens. This third argument seems to be saying what we're regulating is health care, and when you go for health services, you have to pay for insurance. And since insurance won't issue at the moment that you consume the product, we can reasonably, necessarily tell you to buy it ahead of time because you can't buy it at the moment that you need it. Which of these 3 is your argument? Are all of them your argument? I'm just not sure what
let me try to state it this way. The Congress enacted reforms of the insurance market, the guaranteed issue and community rating reforms. It did so to deal with a very serious problem that results in 40 million people not being able to get insurance and therefore not access to the health care market. Everybody agrees in this case that those are within Congress's Article I powers. The minimum coverage provision is necessary to carry those provisions into execution, because without those provisions, without minimum coverage, guaranteed issue and community rating will, as the experience in the states showed, make matters worse, not better. There will be fewer people covered. It will cost more.
So on that ground, you're answering affirmatively to my colleagues that have asked you the question, can the government force you into commerce? And there's no limit to that power.
No, because that's the first part of our argument. The second part of our argument is that the means here that Congress has chosen, the minimum coverage provision, is a means that regulates economic activity, namely your transaction in the healthcare market, with substantial effects on interstate commerce. And it is the conjunction of those two that we think provides the particularly secure foundation for this statute under the commerce power.
General, you've talked on a couple of times about other alternatives that Congress might have had, other alternatives that the respondents suggest to deal with this problem, in particular the alternative of mandating insurance at the point at which somebody goes to a hospital or an emergency room and asks for care. Did Congress consider those alternatives? Why did it reject them? how should we think about the question of alternative ways of dealing with these problems?
I do think, Justice Kagan, that the point of difference between my friends on the other side and the United States is about one of timing. They've agreed that Congress has Article I authority to impose an insurance requirement or other penalty at the point of sale, and they've agreed that Congress has the authority to do that to achieve the same objectives that the minimum coverage provision of the Affordable Care Act is designed to achieve. This is a situation in which we are talking about means. Congress gets substantial deference in the choice of means, and if one thinks about the difference between the means they say Congress should have chosen and the means Congress did choose, I think you can see why it was eminently more sensible for Congress to choose the means that it chose.
I'm not sure which way it cuts if the Congress has alternate means. Let's assume that it could use the tax power to raise revenue and to just have a national health service, a single payer. How does that factor into our analysis? In one sense, it can be argued if this is what the government's doing, it ought to be honest about the power that it's using and use the correct power. On the other hand, it means that since the court can do it anyway, Congress can do it anyway, we give a certain amount of latitude. I'm not sure which way the argument goes.
Let me try to answer that question, Justice Kennedy, and get back to the question you asked me earlier. I do think one striking feature of the argument here that this is a novel exercise of power is that what Congress chose to do was to rely on market mechanisms and efficiency and a method that has more choice than would the traditional Medicare or Medicaid type model. And so it seems a little ironic to suggest that that counts against it. But beyond that, in the sense that it's novel, this provision is novel in the same way, or unprecedented in the same way, that the Sherman Act was unprecedented when the court upheld it in the Northern Securities case, or the Packers and Stockyards Act was unprecedented when the court upheld it, or the National Labor Relations Act was unprecedented when the court upheld it in Jones and Lockwood, or the dairy price supports in Wrightwood Dairy.
Oh, no, it's not. They all involved commerce. There was no doubt that what was being regulated was commerce. And here you're regulating somebody who isn't commerce. Now, by the way, I don't agree with you that the relevant market here is health care. You're not regulating health care. You're regulating insurance. It's the insurance market that you're addressing, and you're saying that some people who are not in it must be in it. And that's different from regulating in any manner commerce that already exists out there.
Well, to the extent that we're looking at the comprehensive scheme, Justice Scalia, it is regulating commerce that already exists out there. And the means in which that regulation is made effective here, the minimum coverage provision, is a regulation of the way in which people participate, the method of their payment in the healthcare market. That is what it is. And I do think, Justice Kennedy, getting back to the question you asked before, what matters here is whether Congress is choosing a tool that's reasonably adapted to the problem that Congress is confronting. And that may mean that the tool is different from a tool that Congress has chosen to use in the past. That's not something that counts against the provision in a Commerce Clause analysis.
It's both necessary and proper. What you just said addresses what's necessary. Yes, has to be reasonably adapted. Necessary does not mean essential, just reasonably adapted. But in addition to being necessary, it has to be proper. And we've held in two cases that something that was reasonably adapted was not proper because it violated the sovereignty of the states, which was implicit in the constitutional structure. The argument here is that this also is maybe necessary, but it's not proper because it violates an equally evident principle in the Constitution, which is that the federal government is not supposed to be a government that has all powers, that it's supposed to be a government of limited powers. And that's what all this questioning has been about. What is left? If the government can do this, what else can it not do?
This does not violate the norm of proper, as this Court articulated it in Prince or in New York, because it does not interfere with the states as sovereigns. This is a regulation that But
that wasn't my point. That is not the only constitutional principle that exists. An equally evident constitutional principle is the principle that the federal government is a government of enumerated powers. and that the vast majority of powers remain in the states and do not belong to the federal government. Do you acknowledge that that's a principle?
Of course we do, Your Honor.
And that's what we're talking about.
And the way in which this Court in its cases has policed the boundary that of what's in the national sphere and what's in the local sphere is to ask whether Congress is regulating economic activity with a substantial effect on interstate commerce. And here, I think it's really impossible in view of our history to say that Congress is invading the state sphere. This is a market in which 50% of the people in this country get their health care through their employer. There is a massive federal tax subsidy of $250 billion a year that makes that much more affordable. ERISA and HIPAA regulate that to ensure that the kinds of bans on pre-existing condition discrimination and pricing practices that occur in the individual market don't occur.
I don't understand your point. Whatever the states have chosen not to do, the federal government can do.
No, not at all.
I mean, the 10th Amendment says the powers not given to the federal government are reserved not just to the states, but to the states and the people. And the argument here is that the people were left to decide whether they want to buy insurance or not.
But, Your Honor, this is what the Court has said, and I think it would be a very substantial departure from what the Court has said, is that when Congress is regulating economic activity with a substantial effect on interstate commerce, that will be upheld. And that is what is going on here. And to embark on, I would submit with all due respect, to embark on the kind of analysis that my friends on the other side suggest the Court ought to embark on is to import Lochner-style substantive due process.
The key in Lochner is that we were talking about regulation of the states, right? And the states are not limited to enumerated powers. The federal government is. And it seems to me it's an entirely different question when you ask yourself whether or not there are going to be limits on the federal power as opposed to limits on the states, which was the issue in Lochner.
I agree, except, Mr. Chief Justice, that what the Court has said, as I read the Court's cases, is that the way in which you ensure that the federal government stays in its sphere and that the sphere reserved to the states is protected is by policing the boundary. Is the national government regulating economic activity with substantial effect on interstate commerce?
But the reason this is concerning is because it requires the individual to do an affirmative act. In the law of torts, our tradition, our law has been that you don't have the duty to rescue someone if that person's in danger. The blind man's walking in front of a car and you do not have a duty to stop him, absent some relation between you. And there's some severe moral criticisms of that rule, but that's generally the rule. And here the government is saying that the federal government has a duty to tell the individual citizen that it must act. And that is different from what we have in previous cases.
Well,
that changes the relationship of the federal government to the individual in a very fundamental way.
I don't think so, Justice Kennedy, because it is predicated on the participation of these individuals in the market for health care services. Now, it happens to be that this is a market in which, aside from the groups that the statute excludes, virtually everybody participates. But it is a regulation of their participation in that market.
Well, but it's critical how you define the market. If I understand the law, the policies that you're requiring people to purchase must contain provision for maternity and newborn care, pediatric services, and substance use treatment. It seems to me that you cannot say that everybody is going to need substance use treatment or pediatric services, and yet that is part of what you require them to purchase.
Well, it's part of what the statute requires the insurers to offer, and I think the reason is because it's trying to define minimum essential coverage because...
Yeah, but your theory is that there is a market in which everyone participates because everybody might need a certain range of health care services. And yet you're requiring people who are never going to need pediatric or maternity services to participate in that market.
With respect to what insurance has to cover, Your Honor, I think Congress is entitled to latitude in making the judgments of what the appropriate scope of coverage is. And the problem here in this market is that you may think you're perfectly healthy and you may think that you're not, that you're being forced to subsidize somebody else. But this is not a market in which you can say that there is an immutable class of healthy people who are being forced to subsidize the unhealthy. This is a market in which you may be healthy one day and you may be a very unhealthy participant in that market the next day, and that is a fundamental difference. And you're not going to know
posing the question I was posing, which is that doesn't apply to a lot of what you're requiring people to purchase. Pediatric services, maternity services. You cannot say that everybody is going to participate in the substance use treatment market, and yet you require people to purchase insurance coverage for that.
When Congress is enacting economic regulation here, it has latitude to define the attributes of essential coverage. That doesn't seem to me implicate the question of whether Congress is in engaging in economic regulation and solving an economic problem.
Are you denying this? If you took the group of people who are subject to the mandate and you calculated the amount of health care services this whole group would consume and figured out the cost of an insurance policy to cover the services that group would consume, the cost of that policy would be much, much less than the kind of policy that these people are now going to be required to purchase under the Affordable Care Act.
Well, while they're young and healthy, that would be true, but they're not going to be young and healthy forever. They're going to be on the other side of that actuarial equation at some point. And, of course, you don't know which among that group is the person who's going to be hit by the bus or get the definitive diagnosis.
So the point is, you take into account that some people in that group are going to be hit by a bus. Some people in that group are going to unexpectedly contract or be diagnosed with a disease that is very expensive to treat. But if you take their costs and you calculate that's a lot less than the amount that they're going to be required to pay. So that you can't just justify this on the basis of they're trying to shift their costs off to other people, can you?
Well, no, the people in that class get benefits too, Justice Alito. They get the guaranteed issue benefit that they would not otherwise have, which is an enormously valuable benefit. And in terms of the subsidy rationale, I think it would be unusual to say that it's an illegitimate exercise of the commerce power for some people to subsidize others. Telephone rates in this country for a century were set via the exercise of the commerce power in a way in which some people paid rates that were much higher than their cost in order to subsidize.
Only if you make phone calls.
Well, right, but everybody, to live in the modern world, everybody needs a telephone. And the same thing with respect to the dairy price supports that the court upheld in Wrightwood Dairy and Rock Royal. You can look at those as disadvantageous contracts, as forced transfers that I suppose it's theoretically true that you could raise your kids without milk, but the reality is you've got to go to the store and buy milk, and the commerce power, as a result of the exercise of the commerce power, you're subsidizing somebody else.
And this is especially true, isn't it, General Varelli? Because in this context, the subsidizers eventually become the subsidized.
Well, that was the point I was trying to make, Justice Kagan, that you're young and healthy one day, but you don't stay that way, and the system works over time. And so I just don't think it's a fair characterization of it. And it does get back to, I think, a problem I think is important to understand.
We're not stupid. They're going to buy insurance later. They're young and need the money now.
But that's
when they think they have a substantial risk of incurring high medical bills, they'll buy insurance like the rest of us.
But
I don't know why you think that they're never going to buy it.
That's the problem, Justice Scalia. That's exactly the experience that the states had that made the imposition of guaranteed issue and community rating not only be ineffectual, but be highly counterproductive. Rates, for example, in New Jersey doubled or tripled. Went from 180,000 people covered in this market down to 80,000 people covered in this market. In Kentucky, virtually every insurer left the market. And the reason for that is because when people have that guarantee of that they can get insurance, they're going to make that calculation that they won't get it until they're sick and they need it. And so the pool of people in the insurance market gets smaller and smaller. The rates you have to charge to cover them get higher and higher. It helps if insurance covers fewer and fewer people until the system ends. This is not a situation in which you're conscripting you're forcing insurance companies to cover very large numbers of...
You could solve that problem by simply not requiring the insurance company to sell it to somebody who has a condition that is going to require medical treatment, or at least not require them to sell it to him at a rate that he sells it to healthy people. But you don't want to do that.
But that seems to me to say, Justice Scalia, that Congress, that's the problem here.
Yes,
and
it's a self-created problem.
Congress cannot solve the problem through standard economic regulation, and I do not think that can be the premise of our understanding of the
whatever problems
problem.
Congress's economic regulation produces, whatever they are,
I think
Congress can do something to counteract them. Here, requiring somebody to enter the insurance market.
It's not a problem of Congress's creation. The problem is that you have 40 million people who cannot get affordable insurance through the means that the rest of us get affordable insurance. Congress, after long study and careful deliberation and viewing the experiences of the states and the way they tried to handle this problem, adopted a package of reforms: guaranteed issue and community rating, and subsidies, and the minimum coverage provision are a package of reforms that solve that problem. I think it's highly artificial to view this as a problem of Congress's own creation.
Is your argument limited to insurance or means of paying for health care?
Yes, it's limited to insurance.
Well, now, why is that? Congress could once you establish that you have a market for health care, I would suppose Congress's power under the Commerce Clause meant they had a broad scope in terms of how they regulate that market. And it would be going back to Lochner if we were put in a position of saying, no, you can use your commerce power to regulate insurance, but you can't use your commerce power to regulate this market in other ways. I think that would be a very significant intrusion by the court into Congress's power. So I don't see how we can accept it's good for you in this case to say, oh, it's just insurance. But once we say that there is a market and Congress can require people to participate in it, as some would say, or as you would say, that people are already participating in it, it seems to me that we can't say there are limitations on what Congress can do under its commerce power, just like in any other area, given significant deference that we accord to Congress in this area, all bets are off, and you can regulate that market in any rational way.
But this is insurance as a method of payment for health care services.
Exactly. You're worried. That's the area that Congress has chosen to regulate. There's this health care market. Everybody's in it, so we can regulate it, and we're going to look at a particular serious problem, which is how people pay for it. But next year they can decide everybody's in this market. We're going to look at a different problem now, and this is how we're going to regulate it. And we can compel people to do things, purchase insurance in this case, something else in the next case, because we've accepted the argument that this is a market in which everybody participates.
Mr. Chief Justice, let me answer that, and then, if I may, I'd like to move to the tax power argument.
Can I tell you what the something else is, so while you're answering it? The something else is everybody has to exercise, because there's no doubt that lack of exercise causes illness, and that causes health care costs to go up. So the federal government says everybody has to join an exercise club. That's the something else.
No, the position we're taking here would not justify that rule, Justice Scalia, because health club membership is not a means of payment for consumption of anything in a market.
Right. That's exactly right. But it doesn't seem responsive to my concern that there's no reason, once we say this is within Congress's commerce power, there's no reason other than our own arbitrary judgment to say all they can regulate is the method of payment. They can regulate other things that affect this now conceded interstate market in health care in which everybody participates.
But I think it's common ground between us and the respondents that this is an interstate market in which everybody participates, and they agree that Congress could impose the insurance requirement at the point of sale. And this is just a question of timing and whether the necessary and proper authority gives Congress, because of the particular features of this market, the ability to impose the insurance, the need for insurance, the maintenance of insurance, before you show up to get health care rather than at the moment you get up
right. No, I think you're just,
get health care.
Unless I'm missing something, I think you're just repeating the idea that this is the regulation of the method of payment. And I understand that argument.
And it is,
it may be a good one, but what I'm concerned about is once we accept the principle that everybody is in this market, I don't see why Congress's power is limited to regulating the method of payment and doesn't include, as it does in any other area. What other area have we said Congress can regulate this market, but only with respect to prices, but only with respect to means of travel? No, once you're in the interstate commerce and can regulate it, pretty much all bets are off.
But we agree Congress can regulate this market. ERISA regulates this market. HIPAA regulates this market. The market is regulated at the federal level in very significant ways already. So I don't think that's the question, Mr. Chief Justice. The question is there a limit to the authority that we're advocating here under the Commerce Power? And the answer is yes, because we are not advocating for a power that would allow Congress to compel.
Could you just say, before you move on, could you express your limiting principle as succinctly as you possibly can? Congress can force people to purchase a product where the failure to purchase the product has a substantial effect on interstate commerce if what? If this is part of a larger regulatory scheme? Is that it? Is there anything more?
We got two, and they're different. Let me state them. First, with respect to the comprehensive scheme. When Congress is regulating, is enacting a comprehensive scheme that it has the authority to enact, that the necessary and proper clause gives it the authority to include regulation, including a regulation of this kind, if it is necessary to counteract risks attributable to the scheme itself, that people engage in economic activity that would undercut the scheme. It's very much like Wickard in that respect, very much like Raich in that respect. With respect to considering the Commerce Clause alone and not embedded in the comprehensive scheme, our position is that Congress can regulate the method of payment by imposing an insurance requirement in advance of the time in which the service is consumed, when the class to which that requirement applies either is or virtually will certain to be in that market, when the timing of one's entry into that market and what you will need when you enter that market is uncertain, and when you will get the care in that market, whether you can afford to pay for it or not, and shift costs to other market participants. So those are our views. Those are the principles we're advocating for, and it's, in fact, the conjunction of the two of them here that makes this, we think, a strong case under the Commerce Clause.
General, could you turn to the tax clause?
Yes, thank you. So
I have looked for a case that involved the issue of whether something denominated by Congress as a penalty was nevertheless treated as a tax, except in those situations where the code itself or the statute itself said treat the penalty as a tax. Do you know of any case where we've done that?
Well, I think I would point the Court to the license tax case where it was denominated a fee and not a tax, and the Court upheld it as an exercise of the taxing power in a situation in which the structure of the law was very much like the structure of this law, in that there was a separate standalone provision that set the predicate and then a separate provision imposing the fee.
But fees, license fees, fees for a hunting license, everybody knows those are taxes. I mean, I don't think there's as much of a difference between a fee and a tax as there is between a penalty and a tax.
And I think in terms of the tax power, I think it's useful to separate this into two questions. One is a question of characterization. Can this be characterized as a tax? And the second, is it a constitutional exercise of the power? With respect to the question of characterization, this is in the Internal Revenue Code. It is administered by the IRS. It is paid on your Form 1040 on April 15th.
But yesterday you told me you listed a number of penalties that are enforced through the tax code that are not taxes, and they're not penalties related to taxes.
They may still be exercises of the taxing power, Justice Ginsburg, as this is. And I think there isn't a case in which the Court has, to my mind, suggested that anything that bears this many indicia of a tax can't be considered as an exercise of the taxing power, In fact, it seems to me the license tax cases point you in the opposite direction. And beyond that, it seems to me the right way to think about this question is whether it is capable of being understood as an exercise of the tax power.
The President said it wasn't a tax, didn't he?
Well, Justice Scalia, there's two things about that. First is it seems to me what matters is what power Congress was exercising. And I think it's clear that they were exercising the tax power as well as.
You're making two arguments. Number one, it's a tax, and number two, even if it isn't a tax, it's within the taxing power. I'm just addressing the first.
What the President said
is it a tax or not a tax? The President didn't think it was.
The President said it wasn't a tax increase because it ought to be understood as an incentive to get people to have insurance. I don't think it's fair to infer from that anything about whether this is an exercise of the tax power or not.
Well, isn't the tax is to raise revenue. A tax is a revenue-raising device, and the purpose of this exaction is to get people into the health care risk pool before they need medical care, and so it will be successful if it doesn't raise any revenue, if it gets people to buy the insurance. That's what this penalty is. This penalty is designed to affect conduct. The conduct is buy health protection, buy health insurance before you have a need for medical care. That's what the penalty is designed to do, not to raise revenue.
That is true, Justice Ginsburg. That is also true of the marijuana tax that was upheld in Sanchez. That's commonly true of penalties under the Code. They do, if they raise revenue, they are exercises of the taxing power. But their purpose is not to raise revenue. Their purpose is to discourage behavior. The mortgage deduction works that way. When the mortgage deduction it's clearly an exercise of the taxing power. When it's successful, it raises less revenue for the federal government. It's still an exercise of the taxing power.
So I suppose, though, General, one question is whether the determined efforts of Congress not to refer to this as a tax make a difference. I mean, you're suggesting we should just look to the practical operation, we shouldn't look at labels, and that seems right, except that here we have a case in which Congress determinedly said this is not a tax, and the question is why should that be irrelevant?
I don't think that that's a fair characterization of the actions of Congress here, Justice Kagan. On the December 23rd, a point of constitutional order was called too, in fact, with respect to this law. The floor sponsor, Senator Baucus, defended it as an exercise of the taxing power in his response to the point of order. The Senate voted 60-39 on that proposition. The legislative history is replete with members of Congress explaining that this law is constitutional as an exercise of the taxing power. It was attacked as a tax by its opponents. So I don't think this is a situation where you can say that Congress was avoiding any mention of the tax power. It would be one thing if Congress explicitly disavowed an exercise of the tax power, but given that it hasn't done so, it seems to me that not only is it fair to read this as an exercise of the tax power, but this Court has got an obligation to construe it as an exercise of the tax power if it can be upheld on that basis.
Well, why didn't Congress call it a tax then? Well, you're telling me they thought of it as a tax, they defended it on the tax power. Why didn't they say it was a tax?
They might have thought, Your Honor, that calling it a penalty as they did would make it more effective in accomplishing its objectives. But it is in the Internal Revenue Code. It is collected by the IRS on April 15th. I don't think this is a situation in which you can say.
So that's the reason. They thought it might be more effective if they called it a penalty.
Well, I don't, there's nothing that I know of that illuminates that.
General,
Certainly.
The problem goes back to the limiting principle. Is this simply anything that raises revenue Congress can do?
No. There's certainly
there has to be a limiting
under the taxing power. And I think, of course, the Constitution imposes some. It's got to be uniform, can't be tax on exports. If it's a direct tax, it's got to be apportioned. Beyond that, the limiting principle that the Court has identified from Drexel Furniture to Kurth Ranch is that it can't be punishment, punitive, in the guise of a tax. And there are three factors the Court has identified to look at that. The first is the sanction and how disproportionate it is to the conduct. The second is whether there's scienter, and the third is whether there's an administrative apparatus out there to enforce the tax. Now, In Bailey against Drexel Furniture, for example, the tax was 10% of the company's profits, even if they had only one child laborer for one day. There was a scienter requirement, and it was enforced by the Department of Labor. It wasn't just collected by the Internal Revenue Service. Here, you don't have any of those things. The penalty is calculated to be no more than, at most, the equivalent of what one would have paid for insurance that you've foregone. There's no scienter requirement. There's no enforcement apparatus out there. So
can the mandate be viewed as a tax if it does impose a requirement on people who are not subject to the penalty or the tax?
I think it could, for the reasons I discussed yesterday. I don't think it can or should be read that way. But if there's any doubt about that, Your Honor, if it is the view of the Court that it can't be, then I think the right way to handle this case is by analogy to New York against the United States, in which the Court read the shall provision, shall handle low-level radioactive waste, as setting the predicate, and then the other provisions were merely incentives to get the predicate met.
So you're saying that all the discussion we had earlier about how this is one big uniform scheme in the Commerce Clause, blah, 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 it really doesn't matter. This is a tax, and the federal government could simply have said, without all of the rest of this legislation, could simply have said, everybody who doesn't buy health insurance at a certain age will be taxed so much money, right?
It used its powers together to solve the problem of the market not providing
but you didn't need
coverage.
that. You didn't need that. If it's a tax, it's only
raising
money is enough.
It is justifiable under its tax power. If I may reserve the balance of my time.
Thank you, General. We'll take a pause for a minute or so, Mr. Clement. Let's see. All right, why don't we get started again? Mr. Clement.
Mr. Chief Justice, and may it please the Court, the mandate represents an unprecedented effort by Congress to compel individuals to enter commerce in order to better regulate commerce. The Commerce Clause gives Congress the power to regulate existing commerce. It does not give Congress the far greater power to compel people to enter commerce, to create commerce essentially in the first place. Now, Congress, when it passed this statute, did make findings about why it thought it could regulate the commerce here. And it justified the mandate as a regulation of the economic decision to forego the purchase of health insurance. That is a theory without any limiting principle.
Do you accept the General's position that you have conceded that Congress could say, if you're going to consume health services, you have to pay by way of insurance?
That's right, Justice Sotomayor. We say, consistent with 220 years of this Court's jurisprudence, that if you regulate the point of sale, you regulate commerce, that's within Congress's commerce power.
All right. So what do you do with the impossibility of buying insurance at the point of consumption? Virtually, you force insurance companies to sell it to you?
Well, Justice, I think there's 2 points to make on that. One is, a lot of the discussion this morning so far has proceeded on the assumption that the only thing that's at issue here is emergency room visits, and the only thing that's being imposed is catastrophic care coverage. But as the Chief Justice indicated earlier, a lot of the insurance that's being covered is for ordinary preventive care, ordinary office visits, and those are the kind of things that one can predict. So there's a big part of the market that's regulated here that wouldn't pose the problem that you're suggesting. But even as to emergency room visits, it certainly would be possible to regulate at that point. You could simply say, there's some sort of mandate on the insurance companies. You have to provide people that come in. This will be a high-risk pool, and maybe you'll have to share it amongst yourself or something. But people simply have to sign up at that point, and that would be regulating at the point of sale.
Well, Mr. Clement, now it seems as though you're just talking about a matter of timing, that Congress can regulate the transaction, and the question is, when does it make best sense to regulate that transaction? And Congress surely has it within its authority to decide, rather than at the point of sale, given an insurance-based mechanism, it makes sense to regulate it earlier. It's just a matter of timing.
Well, Justice Kagan, we don't think it's a matter of timing alone, and we think it has very significant substantive effects. Because if Congress tried to regulate at the point of sale, the one group that it wouldn't capture at all are the people who don't want to purchase health insurance and also have no plans of using health care services in the near term. And Congress very much wanted to capture those people. I mean, those people are essentially the golden geese that pay for the entire lowering of the premium.
Is the government's argument this, and maybe I won't state it accurately, it is true that the non-insured young adult is, in fact, an actuarial reality insofar as our allocation of health